We'll commence proper right now. A very good morning to the Honorable the Chief Justice of Singapore, Sundaresh Menon, President of the International Association for Court Administration, Professor Dr. Luis Maria Palma, President-elect Ms. Pamela Harris, Chief Executive of the Office of the Chief Justice of Singapore, Ms. Judika Ramanathan, Chief Justices, judges, and distinguished guests. Ladies and gentlemen, it is with great pleasure and honor that we welcome you to the International Association for Court Administration Annual Conference 2024. We are proud to announce that this marks the first time Singapore has had the privilege of hosting this very prestigious event. And ladies and gentlemen, this is also a milestone, a very special milestone at that, because this is when we celebrate the association's 20th anniversary as well. Now, I'm very sure that all of you are looking forward to be engaged in fruitful discussions and exchanges over the coming days throughout the entire conference, and as we all explore the latest developments and best practices in court administration. Once again, welcome to Singapore. This year's theme is building trust in the judiciary. Now, over the course of this conference, we will explore how emerging technologies are reshaping court administration and the initiatives put in place to improve access to justice in all our judiciaries globally. Now, it is my pleasure to invite on stage the President of IACA, Professor Dr. Luis Maria Palma, who will be delivering the opening address. Ladies and gentlemen, a big hand.
Esteemed participants, colleagues and friends, thank you so much for joining us. We are deeply honored to hold our international conference for the first time in Singapore, allowing us to celebrate the 20th anniversary of the International Association for Court Administration, IACA, while learning from your remarkable experiences and advancements. Building trust in the judiciary is the main theme of our gathering. Achieving this goal necessitates coming together and learning from each other. Trust is a fundamental value for the judiciary as it establishes the credibility within the society it serves. Nothing is more damaging than disinformation, which undermines the foundations of the judicial system. Upholding good faith, leading by example, fostering teamwork, and ensuring accountability are essential practices we must rely on. Court administration must embody the professional development of these practices, and IACA is dedicated to continuously improving them to fulfill its mission and, in this way, to contribute to social peace. With participation from 240 people representing 53 countries across 5 continents, we are excited to delve into this core topic. We extend our deep gratitude to our distinguished sponsors, whose logos and names are displayed. They include our platinum sponsor, Crimson Logic, gold sponsor, ReadyTech, our silver sponsors, National Center for State Courts, JABS, Epic, For the Record, Topan, and Thomson Reuters, our bronze sponsors, Liberty Recording and Journal Technologies. We greatly appreciate your trust and long-term commitment to the continuous improvement of judiciaries. Dialogue, mutual understanding, and collaboration are operational concepts we strongly believe in and practice at IACA. While it can be challenging, it is the only effective way for us to grow and improve together. Like my Italian ancestors used to say, tutti I dialoghi sono difficili, ma il dialogo è la cosa più bella. All dialogues are difficult, but dialogue is the most beautiful thing. IACA's mission promotes professional court administration and management in emerging democracies and other countries pursuing the rule of law. We sponsor conferences, in-person and online events and forums, education and training programs on court administration and management. Additionally, we serve as a resource for judges, court administrators, managers, and other government officials seeking ways to evaluate and improve court and justice systems. In essence, we aim to help individuals help themselves by identifying necessities, learning from different cultures, and fostering awareness of our interdependence. This contributes to mutual understanding and social peace. The engine of our evolution is not certainty, but doubt. Paraphrasing Lin Yutang when he observed that we are born at every moment of our lives, we learn at every moment of our lives. Like a rider spurring his horse, new challenges arise every day, urging us to devise original and varied solutions for them. Our continuing education and mutual learning from each other tend to facilitate it. This dialectical process, the logic of modern natural science, to which Georg Wilhelm Friedrich Hegel referred, has no end. For all these reasons, our time learning by getting together and listening to each other does not finish by saying goodbye, but see you soon. Our progress, both individually and collectively, relies heavily on it. I take the liberty to quote Chief Justice Sundaresh Menon, who stated during the opening of the legal year 2013 that the legal profession, led by the judiciary, is a custodian of the sacred trust to uphold the rule of law. Its essence is the assurance that no one is above the law, that every citizen should have greatest equality of opportunity, and that the ideals of our national pledge should be pursued by each citizen, exerting his personal efforts and relying on the strength of his abilities, not on his race, language, or religion. It is in the essence of professional court administration to contribute to make that happen. Well-trained and ethical judges need to be devoted to the core reason of their constitutional appointment, which is to deliver justice without time-consuming and cumbersome bureaucratic procedures that otherwise affect the quality and timeliness of their judgments. As then Chief Justice Wee Chong-jin said during the opening of the legal year 1983, the qualities that one should look for in a judge are a burning desire to be fair and impartial, the courage to uphold the law and strike down injustice, to have compassion coupled with an understanding of human frailties, and lastly, a love for the law. Therefore, and thanks to the excellent proposals that IACA Agenda Committee received and approved, we conceived a program where ICT and, within it, AI has a central importance, but as a tool to improve the judiciary, not as an end in itself. We need technical tools that align with our goals to deliver better justice, not the other way around. Continuous training with a problem-solving orientation, utilizing in-person, distance, and blended learning formats is key to achieving this. Therefore, we anticipate engaging presentations from 73 outstanding speakers addressing topics such as AI governance and its impact on the justice system and the legal sector, communication, disinformation, and trust in the judiciary, access to justice and self-representation in court proceedings, people-centered e-services, excellence in the administration of justice, leadership, and teamwork, judicial administration and professional development of court administrators, international case studies such as implementation of the ISO 9001-2015 norms. Justice delayed is justice denied. It's an old quote that countless people repeat, but whose origin remains almost unknown, but not completely. In 1693, Jean de la Bruyère, the great French author and moralist, wrote in an unforgettable book that I read over and over from time to time, whose title is Les Caractères, or Le Mœurs du Siècle, in English, the characters or the manners of the judiciary, that une circonstance essentielle à la justice que l'on doit aux autres, c'est de la faire promptement et sans différer. La faire atteindre, c'est injustice. That is to say, an essential circumstance for the justice that one owes to others is to do it promptly and without delay. To make it wait is injustice. They faced that problem then, we face it as we speak. Last but not least, innovation is crucial for improving the quality of justice. and it must be encouraged through public policy and law. Public policy through strongly support education to creatively identify, solve, and prevent problems. Fostering innovation through the law is crucial. As President Abraham Lincoln noted, the patent system added the fuel of interest to the fire of genius. And both require the judiciary to protect and enforce rights, including property rights, thereby upholding the rule of law. Court administration is fundamentally devoted to contributing to enhance the quality of justice, making good use of both tools, education and innovation. A justice whose quality must constantly improve in parallel to its timeliness with independence and impartiality, and, as Chief Justice Menon said, without distinctions based on race, language, or religion. It is our humble and deepest desire that this conference will contribute to these goals, providing you with opportunities to bring back home fresh ideas, good practices, and new friendships. Thank you all so very much.
Once again, ladies and gentlemen, a big hand for the President of IACA. Thank you. And thank you, Prof. Dr. Lewis, for your welcoming address and the many inspirational quotes setting the right tone for our conference here. Now, ladies and gentlemen, it's my distinct honor to welcome on stage right now our keynote speaker for this conference. Let's put our hands together for the Honorable the Chief Justice of Singapore, Sundaresh Menon.
Good morning. Professor Dr. Louis Maria Palmer, President of the International Association for Court Administration, or IACA, Honorable Chief Justices, Justices and Delegates, distinguished guests, ladies and gentlemen, a very good morning. Let me first add my words of welcome to those of Professor Palmer, as I extend an especially warm welcome to all of you who have traveled from abroad to join us in Singapore. The IACA celebrates its 20th anniversary this year, and the theme that has been chosen for this year's conference, Building Trust in the Judiciary, is particularly apt for these times. For some years now, the world has witnessed declining trust in public institutions. Indeed, a few years ago, distrust was said to have become society's default emotion. And this sits alongside other dramatic challenges confronting our societies, such as the transformative impact of technological advancements, the proliferation of disinformation in public discourse, and the global access to justice crisis. As these challenges sweep through our societies, it is critical that our courts continue to serve as trusted and respected institutions for delivering justice and for upholding the rule of law. This means that now, perhaps more than ever, inspiring and sustaining trust in our justice systems must be the central and overarching mission for our judiciaries. And when we speak of trust in our justice systems, we need to bear in mind how the role of the judiciaries has evolved. The traditional role of the courts was largely limited to adjudicating on disputes and interpreting and applying the law, in each case in a fair and principled manner. It goes without saying that the trustworthy dispensation of justice in individual cases remains a core and fundamental element of securing public trust in our judiciaries. But in recent times, our broader systemic role has assumed increasing importance. By this, I mean the institutional responsibility that we have to develop and operate systems of justice for the administration and delivery of justice to all. This systemic responsibility illuminates the importance of the non-adjudicative work that our judiciaries do, which supports, complements, and indeed strengthens our adjudicative work. It is by performing both our adjudicative and systemic roles with excellence that our courts can secure public trust in our justice systems. And crucially, This is a mission that unites each and every one of us in the judiciary, not just judges and judicial officers. All of us have a part to play in enabling our judiciaries to discharge their systemic role. With this in mind, I will structure my address today in two broad parts. First, I will outline why, although trust is of course important to all public institutions, trust in the judiciary is particularly important. And second, I will then develop my principal thesis, which is that judicial excellence today should be measured by our ability to secure and strengthen trust in three distinct aspects of our judiciaries: trust in our people, trust in our processes, and trust in our systems. Let me first outline why trust in the judiciary is so important, and indeed why it is central to the well-being of our societies. There are several reasons that underlie this. First, trust in the judiciary underpins our legitimacy, and this forms the bedrock of our relationship with the communities that we serve. Alexander Hamilton, one of the American founding fathers, famously described the judiciary as, in his words, the least dangerous of the three branches of government because it has neither force nor will, but merely judgment. But it is right and wise judgment more than force or will that endures in holding a society together over the long term. And the public's acceptance of our judgments rests in large part on the belief that they are the product of a fair and impartial system that is designed to deliver justice. Trust in the judiciary therefore encourages members of the public to approach the legal process with a cooperative and constructive mindset, to accept judicial authority, and to comply with judicial decisions and orders, even and perhaps especially when those decisions go against their personal interests. More fundamentally, trust in the judiciary is a critical component of society's belief in the rule of law. While securing adherence to the rule of law is an endeavor shared by all three branches of government, the judiciary has a particular responsibility for administering a justice system that gives practical expression and life to the rule of law. In this way, the judiciary serves as a key stabilizing force, maintaining public confidence in the rule of law, and thus securing peace and order in our societies. But there is a third reason that trust in the judiciary is so important. At the start of my address, I mentioned the proliferation of disinformation in public discourse as one of the most significant challenges confronting our societies today. This phenomenon of truth decay has been characterized by a set of four related trends. First, an increasing tendency to disagree over facts. Second, a blurring of the line between opinion and fact. Third, an increase in the relative volume and influence of opinion and personal experience over fact. And finally, lowered trust in formally respected sources of factual information. Truth decay poses a particularly pernicious threat to the courts, whose work is built upon the pursuit of truth. But by working to build trust in our courts, we are doing our part to combat the crisis associated with truth decay. The court process and the judicial method exemplify reasoned decision-making, where findings of fact are based on an impartial assessment of the available evidence, and conclusions are arrived at based on the transparent application of principles and legal frameworks. Trust in the courts, therefore, goes hand in hand with a commitment to reason and rationality. And this can be a powerful tool in counteracting the corrosive effects of truth decay. In Singapore, the courts have enjoyed high levels of public trust, but this state of affairs is not taken for granted. Trust in the judiciary is a privilege that needs to be earned and safeguarded, and we must continue to prove on a daily basis that we are worthy of the trust that has been reposed in us. This is why I have said that the central goal of judicial leadership in our times must be to secure trust in our justice systems. This is not a simple or straightforward task, especially amid the various challenges that our judiciaries and our societies must grapple with today. But it is an essential undertaking that all of us, as custodians and operators of our justice systems, should be fully committed to. This brings me to the principal thesis of my address, which is that judicial excellence in these times should therefore be measured by our ability to secure and strengthen trust in three distinct aspects of our judiciaries: our people, our processes, and our systems. Beginning with our people, by which I'm referring not only to our judges and judicial officers, but also to our court administrators, each of these groups of individuals plays an important role in securing and maintaining trust in our judiciaries. I begin with judges and judicial officers because they are the human face of the justice system to the people who come before our courts. Judges have the tremendous responsibility and the immense privilege of administering the law and dispensing justice in each case. In this capacity, we are entrusted with considerable power, which must be exercised with the greatest humility and a vivid consciousness of the extraordinary fact that we have been allowed to sit in judgment of our fellow citizens. This approach to the exercise of judicial power is the first step towards securing public trust and confidence that we will discharge our duties with the utmost diligence, devotion, and integrity. Part of this is about competence. Our judges must be skilled in their core work of adjudication and must be adept at dealing with both existing and emerging areas of the law. But competence today also increasingly requires multidisciplinary knowledge in adjacent fields, such as technology and forensic science, which are themselves growing in scale and complexity. Our judges must be equipped to navigate these diverse bodies of knowledge effectively while maintaining their strong fundamentals in the law. And the rapidly evolving nature of these fields means this must be a continuing endeavor. This is why we have invested significantly in continuing judicial education and training through the Singapore Judicial College, and why we have emphasized the importance, indeed the necessity, of developing our judges as learning judges with a mindset of lifelong and self-directed learning. But competence must be coupled with character and conduct, which are perhaps even more important in maintaining trust. Our courts recently had occasion to emphasize that the admission of lawyers to the bar is about character first before competence because of their role in assisting in the administration of justice. This applies with even greater force to judges and judicial officers who are entrusted with the actual dispensation of justice. And this applies at every level of the judiciary, including the lower courts, where ordinary members of the public are most likely to encounter the justice system. We see this emphasis on character and conduct in many versions of the judicial oath around the world, which require judges to strive to do right to all manner of people without fear or favor, affection or ill will, or some variation of this. This captures the integrity and moral courage that is demanded of judicial office holders. The public must be able to trust that judges are driven by the earnest desire to do the right thing and to achieve justice in each case. Individual judges might not always arrive at the right answers, and at least one party will typically be dissatisfied with whatever decision the judge makes. But all parties should minimally leave with the confidence that the judge arrived at that decision honestly, diligently, fairly, and impartially. Judges should also conduct themselves with composure, empathy, and courtesy in a way that respects the humanity of the people standing before justice and that upholds the dignity of the judicial office. But the people who make up our judiciaries are not limited to judges and judicial officers. Court administrators are a key constituency of our judiciaries, and they play a vital role in the delivery of quality justice to our users. The direct and indirect contributions of court administrators to all the dimensions of the work of the courts, which I will discuss in this address, go hand in hand with the work of our judges and judicial officers. The competence, character, and conduct of our court administrators are therefore equally essential to uphold trust in our judiciaries. We must therefore continue to invest in the professionalization of our court administrators through training and development. At the same time, all our court administrators who, alongside our judges and judicial officers, are representatives of our judiciaries, should hold themselves to the highest standards of ethics and integrity and strive to achieve excellence. All this makes it critical that our judiciaries attract, select, and retain the right people and clearly communicate and reinforce our expectations of all our people through appropriate codes of conduct that are swiftly and robustly applied and upheld. Judicial leaders should also lead by example, holding ourselves to the highest of standards and seek to inspire our younger colleagues to do the same. Trust in our people, however, is part of a larger picture. And this leads me to the second aspect of trust, which is trust in our processes. And I want to highlight two particular dimensions of this: truth and transparency. The public should trust that the court process is based on the fair, honest, and proportionate quest for truth, and that judicial decisions are based on and reflective of the truth. The speed at which falsehoods can gain widespread traction in the modern world has exacerbated the proliferation of disinformation that has affected many of our societies. And this has been further aggravated by the growing capabilities of generative artificial intelligence, or AI, to create and amplify misleading or inaccurate information. If we are to safeguard the actual and perceived integrity of the judicial process amid this maelstrom, it will be imperative for judiciaries to ensure that the sanctity of truth within the courtroom is maintained and is also seen to be maintained. Of course, the work of judges and judicial officers plays a key part in upholding public confidence that our courts continue to be reliable truth seekers and truth finders. But there are also other important steps we can take to address at least some of the emerging challenges, such as by developing robust governance frameworks and guidelines to oversee or regulate the use of AI in litigation and adjudication. The New Zealand judiciary was among the first to publish guidelines for the use of generative AI in courts and tribunals, And the Singapore courts have similarly issued a guide for this purpose, which came into effect just last month. As the capabilities of AI continue to grow rapidly, we will need to be agile and forward-looking and proactive to ensure that our judiciaries continue to be equipped to meet the challenges that will be thrown up by these developments. The second dimension of trust that I want to touch on centers on transparency. Justice must not only be done, it must be seen to be done. And public knowledge about the courts has long been closely linked to public trust in judicial institutions and processes. Hence, the traditional view that the courts should hold themselves aloof from the public and simply let their proceedings and judgments speak for themselves needs refinement and updating for today's world. I suggest that judiciaries should develop effective strategies for public communications and outreach and promote public understanding of the work of the courts. This includes raising awareness of how the courts generally approach the task of deciding cases, as well as an appreciation of the limits of what the courts can do, especially in cases that involve socially polarizing issues. To this end, our Supreme Court publishes summaries of significant judgments on its website and social media channels, including the Singapore Judiciary's official WhatsApp channel. We have also sought proactively to engage with a wider audience through a series of conversations with the community where our judges led sessions exploring specific aspects of our work, ranging from family justice to environmental law and climate change litigation. Efforts like these foster a deeper understanding of what the courts do, which provides a foundation on which trust in our processes can be built and sustained. They also help to dispel myths and correct misconceptions, and can thus be powerful tools for combating disinformation. But of course, effective communication is never a one-way exercise of delivering our messages to the public. Instead, it requires a two-way dialogue or a conversation. We should therefore also be listening actively to the feedback and concerns of our users as we consider how our processes might be further refined and improved. I turn to the third and final aspect of trust that I want to touch on today, and that is trust in our systems. I suggest that this requires us to pursue several key priorities. First, efficiency and effectiveness, which Professor Palmer touched on and which I will deal with together. And second, inclusivity. Beginning with efficiency and effectiveness, the public should be able to conduct its affairs with the confidence that the court system will provide a robust mechanism for the timely and orderly resolution of any legal disputes that they may become embroiled in. This is particularly important perhaps for commercial parties who look to an efficient and effective court system to provide stability and predictability in their dealings through the assurance that any failure to comply with one's legal obligations will be met by the swift and robust response of the law. Maintaining our efficiency and effectiveness in an increasingly fast-paced world is an ongoing effort that requires our judiciaries actively to consider how we can streamline and improve our systems in new and innovative ways. Just as an example, we recently launched the Express Track scheme in the High Court to facilitate the more expeditious and effective resolution of certain civil matters that are capable of being resolved within 4 days of trial. And while the efficiency and effectiveness of our courts depends in large part on the industry and diligence of our judges and judicial officers, the work and perspectives of our court administrators are instrumental in keeping our processes running smoothly and in identifying areas for refinement. For instance, our court administrators help maintain a system-wide view of our timelines in disposing of cases and our compliance with case management targets for different types of proceedings. And they often spearhead the adoption of new technologies to advance these goals. We should therefore encourage a culture of innovation at all levels of our judiciaries and equip judges and administrators alike with the skills and resolve to continually pursue enhancement and reform. The public should also trust that our judiciaries operate a system for the administration of justice that upholds the precept that all are equal before the law. One aspect of this is the need to ensure that judicial systems operate independently and impartially and do not produce outcomes based on judicial bias against or in favor of any social groups, political affiliations, or personal agendas. Even the perception of this would be deeply damaging to trust in any judiciary. But another aspect of the idea that all are equal before the law involves ensuring that court systems are accessible to all whom they are meant to serve. I will refer to this as the need for inclusivity, and this is a critical component of our work in discharging the systemic role of our judiciaries in administering a system that delivers justice for all. If we are to safeguard public trust in our justice systems, we must ensure that they do not come to be perceived as the preserve of a privileged few, beyond the reach of ordinary people. And the need to address this concern has become particularly pressing in recent times because of rising socioeconomic inequality in many parts of the world, which is said to have created diverging trust realities for those in the top and bottom quartiles of income. This is why access to justice should be a key priority for judiciaries today seeking to secure trust. In the new normal that our courts are operating in, a significant component of actual and potential court users are self-represented persons. We must ensure that as far as possible, these would-be litigants are not shut out of our justice systems on account of the resource or legal literacy gaps that may stand in their way. Access to justice must therefore be understood as an essential dimension of our efforts to achieve judicial excellence. Even the best justice system with the best people and resources would be absolutely worthless if it were inaccessible to those who need to turn to the courts to resolve their legal problems. Or if those who do try to seek recourse through the courts are not given a fair chance to have their voices heard. But the reality facing the world today is that there is an access to justice crisis. With this in mind, the Singapore courts have made significant efforts to provide legal information and practical assistance to help self-represented litigants navigate our justice system. These efforts have included exploring the potential of technology to improve the accessibility of our systems and processes. For instance, our Office of Transformation and Innovation is collaborating with Harvey, the AI startup behind the eponymous tool, and our goal is to assist self-represented persons in the Small Claims Tribunal with assembling the evidence, preparing their claims and submissions, and understanding the material put forward by the other party. We hope to formally launch this sometime next year, and as I mentioned to Professor Palmer, we welcome you to come and see how it might help address the access to justice needs in your society. Similarly, our Access to Justice, or A2J program office, has been central in driving our judiciary's transformation into an ever more outward-looking and user-centric institution. It has already completed 14 projects since it was established less than 2 years ago, and many more are in the pipeline. The A to J program office has also brought together a work group of volunteer officers from across our judiciary who have stepped forward to take on various projects on top of their other work commitments. And this is perhaps the best example of their commitment to the mission to secure justice. This is an excellent example of how all of us, judicial officers and court administrators alike, can contribute directly to the work of our judiciaries in advancing access to justice. I close by returning to the point with which I began. Trust in our judiciaries is not only built on the court's adjudicative work in individual cases, but it increasingly rests on our ability to discharge our broader systemic role, which is assuming ever greater importance. This mission involves all parts and all levels of a modern judiciary, from judicial education and judicial policy to communications and outreach, to technology and innovation, to access to justice, to name just a few of the areas I've touched on. Court administrators and court administration are an indispensable part of our people, processes, and systems for administering and delivering justice. Pursuing this mission will no doubt require a substantial investment of time and resources, but it is an immensely worthwhile endeavor, not only because it enables our judiciaries to better discharge their twin roles, but also because it contributes to securing the central and trusted place of our judiciaries and societies founded on the rule of law. While the terrain around us may not be easy to navigate, we become stronger with the benefit of one another's experiences, perspectives, and insights. I'm therefore delighted to welcome so many of you who've joined us from so many countries. I was told just before we started that we have representatives from 53 countries here today, and that's fabulous. I wish you all a fulfilling conference in the coming days as we discuss these important issues and strive together to achieve and maintain judicial excellence in this challenging world. Thank you so very much.
Ladies and gentlemen, a big hand for Chief Justice Sundaresh Menon. Thank you. Thank you, CJ.